Good day and welcome to this newscast. This is a newscast which has been put together by the New Law Journal and is intended to look at the survey of litigation trends now 6 months on from Jackson. And there is a lot to talk about post-Jackson. In a way, not the nub of the Jackson reforms, but certainly we're seeing the influence and decisions almost every day on Jackson themes at least. I'm joined here by Dominic Regan. Professor Regan will be well known to those watching. He is a Professor of Law at the City Law School and a New Law Journal columnist. And I'm also joined by Neil Smith. Neil Smith is Head of Lexis PSL Dispute Resolution and indeed was a litigator in times past. Dominic's going to deal with the question of what's going to happen in 2014. This isn't the end of Jackson. We're going to see a lot more changes in 2014 and on we go. It'll be very interesting to hear what we're going to see. And Neil is going to deal with budgeting, questions of budgeting, and in a way that's the effect we've seen with Jackson up to now. But let's turn to the survey itself and the answers. In a way, I don't think there are going to be any surprises in the survey answers. They deal with many issues, including DBAs, CFAs, budgeting, costs, and that big question that we all ask is, well, is budgeting going to increase or decrease costs? And we'll see what most litigators say. And let's just turn to the survey itself, and I think we've all got a copy of the survey in front of us, and we can deal with, just run through it in the order. In a way, the first part deals with CFAs and DBAs, and quite early on in the DBA regime, we well know, and it's been publicised much, that the DBA regulations really aren't working, and therefore there are very few people taking up DBAs. One or two, I've done quite a lot of sessions with other solicitors talking about DBAs. Every now and again you get one person put their hand up and say that they've had a go at them, but really very rare. And we know the reasons. We'll discuss those reasons in a moment. But just early signs, the survey asks, have you stopped offering or restricted your use of conditional fee agreements? 34% said yes, so they have restricted and changed their use. And 53% said no, so they're continuing. Personally, I think CFAs are here to stay. I just think the market demands CFAs, and personally, I can't see much is going to change. Dominic, you're nodding over there. Tell us what you think.
I totally agree. On the DBA front, it's one of the things that's going to change next year, I think, is to make them workable. But immediately I just want to utter the caution that if anybody's doing a DBA now, they really must be so careful, because there is nothing in the regulations about what happens if the parties fall out. And also, of course, the client is going to have a great incentive to try and knock the DBA over and therefore hang on to all of the money. And I'm being very anxious that solicitors don't enter into DBAs and then find that they are effectively worse off than before they took on the client.
Yeah. I mean, I haven't actually heard of anybody in practice who has used a DBA yet under the new regs, and I think for obvious reasons. I'd be afraid to use them at the moment.
Yeah. I've come across one firm that's done it, and I thought, well, they're good luck. Yes.
What model did they draft their own?
They drafted their own, but I mean,
scary.
Super scary. Yes. Yes.
The only one I've heard of someone doing it is a claim against police, where there was a high likelihood of success.
Right.
It was quite a lot late on in the claim, and they entered into a DBA.
Sure.
In order
Any
to
idea
pursue
what sort of level of fee they will? What percent?
That's another great. Well, I mean, the difficulty is the percentage. So
that's another problem. Yes.
I mean, we all know that the problem with DBAs relates to the regulation and the fact you can't mix them with a CFA or you can't mix them with an ordinary retainer. Yeah. We've all got used to doing CFAs on that basis, so we have a look at a discounted model of CFA, and that works. I mean, it all works in terms of business because we need the cash, we need to cash in our WIP from time to time, but carrying the whole of a DBA through to on a big case particularly is going to be difficult, I think.
Well, that's one of the things that I'm told is definitely going to change in April next year.
Yes.
So
Well, we
I'm
always
sure-
get mixed messages from the MOJ as to
Right,
whether they're
right.
going to do anything or not.
The fact that hybrid DBAs are going to be allowed, because I think
That's
that would
the
be
real. That's
the-
the crunch. Yes. Yeah.
Yeah. Well, not surprisingly then, in the survey, if we have a look at the response to the question number 2, you do not intend to use DBAs. Please give your reasons. I think that's supposed to be, do you propose to use them? And 16%, the vast majority, at least of this questionnaire, have say wait and see. And I think that's the
Yeah.
point, is
Absolutely.
we're all waiting to see what happens.
And that may, David, if I may say, maybe perhaps a more general principle post-April. I think a lot of firms have just keeping their heads down because they're so uncertain about just generally what's going to happen with all of litigation, not just DBAs, that I think there's been a marked drop-off in the number of cases being issued. And I think people are holding back, they're relenting, and they're waiting to see how things pan out, which is, of course, what happened with the Wolf reforms as well.
And I think it's a real shame that because CFAs are less desirable now, certainly for clients, it's a shame that there isn't something to step into its place, and DBAs could have been that thing.
Yeah.
So hopefully when it's sorted, we could see the increased use of DBAs, and that would be a great thing.
I don't know that DBAs are the answer. I mean, the trouble with DBA is, if you look at the model of a DBA, the claim's got to be really quite high.
Yep.
To make
it's got to
it
be along
economic.
so third-party funders will tell us, well, don't come to me for a claim less than 3 million or something like
Yes,
that. I mean,
yes.
that's the vast majority of them, at least. And DBAs are quite similar in that,
Yep.
that you've got to match the cost level
Yeah.
with the likely settlement figure.
Sure.
There's no point looking at the claim. You've got to look at the
So-
settlement figure. So
yes.
if we look at a claim of, I don't know, £1 million, which is a big
Yep.
Yeah.
sum. Well, what's that going to settle at? You've got to work on the basis that's going to settle at about 500,000.
Yep.
Sure. Yeah. So immediately the cake is halved.
The cake is halved. And the one thing I think professionally we have to do is ensure that we don't become the litigation.
Yes.
As in that our fees really become the litigation.
Yep.
at the
Yeah.
end
Which
of the day.
cannot often happen.
And the client's
Yeah,
getting
yeah,
nothing.
Yeah.
You know, which
yes.
I think is difficult.
As a firm, have you given much thought to entering the DBA market when and if things resolve?
Certainly we will look. We do a lot of CFAs and I think we'll do some DBAs. I think we will certainly look at it in the right sort of claim. But let's move on to other elements of the survey. What steps have you taken to prepare budgets in accordance with the new rules? Well, there we are, budgeting.
Yep.
The question of whether you have to comply. I mean, we've got the transitional provisions at the moment. I have to say, as a practitioner, I find them extremely confusing.
Yep.
These transitional provisions. But 55% say that they've preparing with internal training. And you, as Neil, as a PSL provider, must have that in mind.
Yep.
What do we think? Do we think firms are ready?
I think
Preparing?
internal training is absolutely a big part of the answer. I'm surprised that the percentage for investment in software isn't a little higher, because I think it cries out for a software solution, because the danger is not monitoring what your actual costs are as against the budgeted figures all of the time.
Yes.
Because as we know, as soon as the actual cost starts stripping out the budgeted costs, you should go to court immediately and inform the court.
Yes.
So that surprises me a little. I only hope that the internal training is of a sufficient quality that it's going to bring fee earners up to speed.
Yes.
Yeah.
Yes.
I still get the impression
Dominic.
I think a lot of people, and I think rightly, are using external cost experts on the budgeting. I did a talk for the Association of Cost Lawyers about 10 days ago, and they're just overwhelmed with work. These
Manna from heaven for this.
Well, of course it is. It is, but it's so important because we know from I think the cases that one, you've got to get the budget right in the first place, and then two, you've got to make sure that it stays right. And getting it right in the first place is just everything.
Yeah.
I think that's the message that the judiciary is sort of sending out is
They are.
you've got to get the budget right in the first place.
That was, I think, Elvenite, wasn't it?
And it's difficult. It's not easy to get it right in the first place. And one, we're going to talk about budgeting, but one element there is going to it early.
Yeah.
Don't leave it too late, particularly when when you are looking at counsels' fees, experts' fees,
Yes.
you've got to enjoin counsels'
Yes.
clerk into
Yes.
it.
I think the cases are a really useful salutary warning to solicitors, and the good thing about the cases is it illustrates the sorts of things that we can all avoid. You know, it's a tricky process anyway, but there are a lot of self-help measures that practitioners can use, and I'll pick up on a few of those.
You'll pick up on those. Well, let's turn to the remainder of the survey. Do you think budgeting will reduce or increase costs? Well, here we are. Here's the telltale
That's the
sign.
worry.
69% say that they'll increase costs. 21% say it'll decrease costs, and 9% say it'll be no change. What's the view?
Well, I mean, if I can just make the point that I watched budgeting for Lord Justice Jackson in the pilot, and I was utterly neutral, and I saw a lot of good come out of it. And in particular, which these statistics would not perhaps pick up on, but one of them, I was discussing with Neil earlier, one of the major benefits is a judge at the outset not just looking at the allegations, but actually looking at the proposed spend and the number of times that people were turning up with crazy schemes. And because the judge was saying, well, no, you don't need so many experts, or you don't need so many witnesses. And there was an instant and significant saving achieved. And I thought that in itself was profoundly beneficial, let alone, I mean, of course, these are numbers, and numbers move, and one can, as we've seen, one can change the numbers, but I still remain, an advocate of budgeting.
Yeah.
Do we think do we think these figures are simply indicative of it being such a new process and when it beds down? Because it's difficult to disagree with the idea that it's obviously sensible.
It is obviously sensible, and of course, we are, as David said in his introduction, we are very, very early on, and I think it's a bit like, once one gets up to speed, and once it becomes sort of a more normal and everyday process, it seems to me that it will become more fluid, and people will just sort of get into it, and it's just like it's learning to do something, and it's slow and it's laborious, but
in theory, used correctly, it's as much benefit to clients as it is.
It is. Clients and indeed in certain areas like defamation, where it's been well established. I mean, people should be, frankly, on top of it now.
Yes, yeah. Well, I mean, it is the flavour of the month, budgeting.
Yep, it is.
I think from the practitioner's point of view, well, we're on a steep learning curve at the moment in terms of completing that form. I don't think the form helps.
No.
I think there are quite a lot of questions about the form, but we are on a steep learning curve, and of course the maybe why people are saying it will increase costs is because they're spending a lot of time on it.
Yeah, exactly.
And with familiarity, those costs should go down.
Exactly. Again, it's mastering. Familiarity is precisely what it is. It's getting the hang of it, and I mean, I think it won't be that long, I don't think, before we have something that is utterly sort of software driven, and people will turn up at courts with the new iPads or the laptops, and the numbers, the judge, I'm not here, and the numbers will be recalculating, repopulating as we go, and that's how I see it working.
That's exciting. Sorry.
Well, I was just going to say, it's just picking up that, is one thing some judges are saying is, could you please bring along an Excel spreadsheet?
Yes,
so that you can change it.
But actually online,
as we go along.
Fantastic.
Absolutely change it as you go along. Can you provide it in an Excel spreadsheet?
Sure. All right, and if I may, one more nuance, because I was with District Judge Hill last week, and some judges are now saying we want the clients there too, so that they can hear the numbers, which I think is also very interesting.
Yeah. Well, do you remember that was a wolf theme?
It was. The court
for the CMC.
The court could ask the CMC.
It's one of the powers of the court, isn't it? In Part 3, the court can require the parties to attend.
I have to say, I don't think it ever happened.
It didn't.
If I remember.
No. I think it happened once. Because there was one case that went to the Court of Appeal on who was the client, but yeah, exactly. But it could get more interesting, and if the client is there, and in particular, if they're hearing, it concentrates the mind wonderfully.
It's a worry for the solicitors potentially.
Yeah, and it brings it home to the clients when judge saying, well, I think so. If your client loses, you're going to be paying 1.3 million.
Yep.
That is something that would be a slight start to the other party.
Especially if your claim's only worth $500,000. That's
Exactly.
Come on, we'll move on to new rules on disclosure. Do you think the Jackson reforms, including the new rules on disclosure, will increase or decrease costs? And again, you've got 59%, so you've got a majority saying they'll increase costs. And again, it's a period of change for disclosure. And I'd say I've been doing it, filling in the disclosure report, having long discussions with counsel about what sort of disclosure we want. I'm tending to think that this is actually likely to increase because it's certainly front load costs.
Right.
Well, I think a lot of these statistics are revealing, to a certain extent, a knee-jerk reaction on the part of the survey participants, because obviously they're saying everything's going to increase and take longer. I think that at first for disclosure it might increase costs, but ultimately disclosure is such an expensive phase of the proceedings that if you address the sort of disclosure which is appropriate early on, I think it could help.
It's an investment, it's a payback.
This is what I'm hoping, but you're at the front line, you know. You can see better.
I'm a claimant's lawyer, and our difficulty as claimants is actually knowing what the other side have.
Yes.
It's difficult to predict. I was trying to fill in a disclosure report the other day, and I don't know where they keep the documents. I don't know what documents they've got. So
it's in your interest not to narrow down the disclosure obligation to a large extent.
Well, in fact, we were having that very discussion about it.
Yeah. But isn't the problem, David, the form? A point you've made eloquently before now. The problem is not the exercise; it's that the form is rubbish.
Yeah, well, the form. I think there are some printing errors on the form. I think it refers to the wrong parts of the CPR.
Yeah, well,
never great.
It's early days.
Early days.
Yes.
Yeah.
Right.
Teething problems.
Let's turn to the last two questions. Have you reviewed your litigation strategy post April? It says 01 here. I think there's a mistake there, but obviously earlier this year. 63% say yes. 36% say no. So have you reviewed your litigation strategy?
I'm a bit worried about the 36%, I'll be honest with you.
Particularly when they actually said, what litigation strategy?
Exactly.
Yes. What is a litigation strategy?
That is a very, very worrying statistic. There's not a lot you can say about that.
No,
Let's turn to the final question then, which is, do you think the Jackson reforms, as promised, will increase access to justice? Well, that depends whether you're a claimant or defendant lawyer, I think.
There are so many sort of plates spinning out there, and it's really how it's going to bed down. I mean, things like, for example, qualified one-way cost shifting could actually be incredibly attractive in the limited area where it operates. So one can see positives there. He wanted and got pretty much the integrated package that he was after. But a lot is down to judicial attitude. It is plainly down to the conduct of the parties and how they sort of embrace this and whether they try to sort of block it or go with it. But honestly, I just think it's too early to tell.
I think if you qualify for QOCs, which is difficult to say,
yes.
I think you are
That's
going
easy
to be
for you to say.
Yes. You're going to be delighted, because it puts you at a potential advantage.
A real advantage, yes.
But just taking a policy point is so I don't think Jackson thought that he was increasing access to justice for claimants. I think he appreciated he was reducing access to justice, non-recoverability of ATE, non-recoverability of the success fee is always going to restrict access for claimants. His policy point would be, yes, but I'm increasing access for defendants because they don't suffer those penalties.
Yes. He's achieving all-round fairness rather than anything that's partisan.
Absolutely,
yes.
and I think the answer to that is yes in those terms.
Yeah. So QOCs it was clearly Lord Justice Jackson's attempt to redress the balance of the irrecoverability of the success fee.
Indeed, and the Simmons and Castle putting damages up by 10%, and you have this sort of cumulative effect where he takes with one hand and gives with another.
And this may well be off piece slightly, but on the Simmons and Castle point, increasing general damages by 10%, that's a difficult concept in itself, isn't it? Because for general damages, it's a relatively arbitrary figure anyway. So what's to stop a judge still saying, okay, I would have ordered this, knocking it down and then adding the 10% back on?
I know. It's.
What do you think?
I don't know. They've just, for those who do injury, they have just published a new edition publication of the guidelines
Yep.
with the numbers in. So we now have the
Yep.
as it were the new numbers
Yep.
in black and white. But I think the truth is that 10% on generals in most cases is peanuts,
Yep.
isn't it?
Yeah,
So.
So that's a survey. It's quite early on.
Yeah, it's a very good. It's a representative survey. We had a lot of respondents, which is really healthy and promising.
Very
Yes.
much so, and
Yeah.
indeed the intention is to do it quarterly, and
Good.
we will see how the trends change. Whether people think that in fact Jackson's a good thing or a bad thing, I think we'll see over the next year. I don't think we've yet seen the effect of the major change, which is non-recoverability of ATE, non-recoverability of the uplift, and I think that's going to take a year or two.
Yeah, we're in a long run off there.
I think we are. Everyone was rushing towards 1st of April.
And then we'll have to get used to new things again come 2014 anyway.
We will.
We're going to come to that in a moment, but we're going to turn to you, Neil. You're going to deal with some update on budgeting questions.
Yep. Well, what I'm intending to do, and I hope it isn't too dry, is very quickly canter through some of the most important cases, but rather than just repeat the facts, just to try and pull out a few practical tips.
Great.
And obviously, I'd welcome some interjections whenever you see fit. So the first case, Henry, was an interesting case. This really wasn't cost budgeting operating in the way in which it was intended at all. So Court of Appeal decision, the costs came in way in excess of the budget. However, the costs were allowed because Lord Justices Morbick and Aikens felt that the increase in the costs budget was caused by the conduct of the other party. So not a great start, I don't think, for cost budgeting in action, albeit that the judges in that case said that post the 1st of April they would be stricter. So I'm going to skip on a couple of cases. So we had Murray and Dalman. The key point to take away from that, it was a simple failure to tick a box on the precedent H. That box was intended to demonstrate that the success fee and the ATE premiums were to be excluded from the figures. The other side leapt upon that and said, okay, well, you're not having a success fee and ATE premium. The judge said no, it was a simple failure to tick a box, and in any event, the precedent H form changed to alter that assumption. So interesting case. Now, Slick, Seating and Adams. I really like this case, and I think it's well titled because I think it shows how slickly, to excuse the pun, cost budgeting could work. Now this was Judge Simon Brown, and this is good for practitioners because this showed. I'll give you a few figures. Claim was £4.4 million. The approved budget was £359,000. The total incurred came in at £351,000. Now, for me, first of all, that proves fantastic forecasting on the budget. I don't know how they predicted it as well as that.
Remarkably proportionate costs, may I say.
Absolutely. I mean, it's the dream case to demonstrate how cost budgeting can work. You know, all of the percentages look great. Exactly.
I seem to remember though the defendant didn't turn up. Was that the one where the defendant didn't turn up?
Yes.
Absolutely that. The defendant missed loads of hearings. He didn't exactly cover himself in glory. So
that kept the cost down, you see.
It would have been a lot higher. And the good thing about it, if you stay within budget and issues don't fall away, because of course if issues fall away, you've got to revise your budget downwards. If you stick within budget, you're potentially getting 100% recovery, whereas pre-cost budgeting on taxation, you've been probably down at 60-65%.
Yes.
So this is...
Yes. Because is this a case where the judge said, right, have the budget figure as your costs?
Absolutely that.
Yeah. Well, that's very attractive. And in fact, I've heard a number of judges say, if I've budgeted and people are coming in on budget, I have absolutely no appetite to do the costs all over again at the end, and that is where we may see the payback. That you have the front loading, but then at the tail end you don't have all this extra activity to put it to bed.
Completely. I mean, I think that's very attractive to practitioners if that starts filtering through. Okay, then we've got Elvenite. In the TCC, Mr. Justice Coulson delivered a lot of cost decisions, some fantastic guidance, actually. Cost management pilot scheme. The claimant lost. The defendant won £3,500 on the counterclaim. Okay. Defendant's budget, these are some alarming figures, defendant's budget was £264,000. His actual cost came in at almost £500,000. There'd been no application to revise the budget, so significantly in excess. What attempts were made to try and get the higher figure? Well, there was an argument on indemnity costs. Now, if you get indemnity costs, the indemnity costs weren't actually ordered here, so all of this is obiter.
Sure.
Does the fact of getting indemnity costs mean that you are able to get your 500,000 or your cost budget of 264,000? The court said the cost management order is still the starting place.
Yeah.
So otherwise you could see that clever practitioners would obviously argue for indemnity costs all of the time. Just a couple of things I want to pick up on that case and move on to the others. Some other tips which were made in this case. Now, to depart from the cost budget, you've got to have a good reason to depart. What is the court looking for to demonstrate that? Well, Mr. Justice Coulson in this case said that if the pleadings aren't significantly amended and the issues are the same as at the start of the case, you're going to have a job convincing the court that the cost budget should change.
Yeah.
Okay?
Yeah.
Also, not if you've just made a mistake filling in your cost budget at the beginning. That's not going to count. Makes sense. And also, Mr. Justice Coulson commented in this case that the increase in the expert fees were, a great word, astonishing.
Yes. Well, that was because the experts sat there for the whole of the trial.
Exactly
Yeah.
that, every day.
Just lunatic.
Every day.
Yeah.
So there we go. Okay, moving on to the three final cases I want to touch upon briefly. Mitchell, perhaps we've heard of that case.
Oh,
Yeah.
Mitchell. Yes. Are we all waiting?
We are.
My breath is bated.
I understand. I can't steal the glory on this one. The inside information, the date for the
7th November.
7th of November.
7th of
We're
November.
agreed.
Yeah.
We are.
Okay. This is a case where a lot of the problems could have been avoided. Unfortunately, the budget was only filed the day before the CMC, and even then, only because the judge took the step of calling up the claimant. Anecdotally, I've heard that this has potentially resulted in a loss to the lawyers or the client of over £500,000. So we're talking significant issues, because obviously if you haven't filed your cost budget, you can only get your court fees. I think what is good to take away from this case are the reasons that the successful party gave for not filing the budget on time. And these were given short shrift. So I think it's worth picking up on them so we know not to try these tactics. The argument was that they were only a two-partner firm acting against a really big city firm of solicitors. That a senior associate had recently left. These are all excuses that were given for the late filing of the cost budget. That others were on maternity leave. That they'd had a busy previous week with hearings. There'd been some problems with communication with counsel. General message from the court, not good enough. No. I'm afraid I can understand that. And the other thing I think to take away from this case is it was made clear by Master MacLeod that cost budgeting obviously should be an iterative process. You shouldn't start thinking about it 7 days before the deadline for filing the budget.
Well, that's a problem.
And that's the message. You know, so.
Yeah. And supplementary arguments, if I'm very quickly mentioning, is that budgeting is well established in defamation.
Yep.
It's not a new thing.
Absolutely.
And also, I think that some of the judges are saying, defamation work is incredibly lucrative. So if you're going to be doing this work, then you've got to be up to it. You know, the rewards are significant, and therefore we expect the best of you.
Absolutely.
Which puts the claimants, I think, in an invidious position.
Yep.
We shall see.
Yeah.
Well, let's hope so.
Yeah.
Okay, two final decisions I just want to touch upon briefly. Willis and Rundle and the Board of Trustees at Merseyside against AEW. So, Willis and Rundle, I think, is an interesting case on proportionality. The only thing I really want to say about Willis and Rundle, it was Mr. Justice Coulson again in the TCC, cost budgeting pilot scheme. I think these figures are equally illustrative as against the good position which was demonstrated in slick seating. So in this case, the value of the claim was £1.1 million. Combined budgets, have a guess?
Combined budgets?
Yeah.
1.1 million.
750.
No, I'm afraid not. 1.6, it's like a game show. 1.6 million.
Right. Okay.
Higher, lower.
No, I'm afraid it's constrained at 1.6 million. So the budgets weren't approved. Okay. The good thing that came out of this case for practitioners is simply because the budgets weren't approved, there was a concern that that would mean no recovery on costs at all.
Yes.
That wasn't the case.
Right.
Okay.
Okay.
A couple of other useful items to take out of this on the process of cost budgeting. You know, the contingencies section of the form, which is potentially useful to practitioners. Don't just throw in a big lump sum in there without explanation. So in this case, they threw in 55k without explanation. Break it down and say why it is that you think.
Well, you've got those columns at the end of the form for the contingency element, if I remember.
Yeah.
That's it. So here,
and what sort of, because you sort of can anticipate, is it maybe up to 4? I think at one stage,
It's 4, yeah. There was some problem with the form to begin with, but I think they've
if there's any, just one bit, but in training, I just have no, the judges in training were told that, you know, as you said, it should be something specific, like specific disclosure. So you're not just saying 55,000 contingencies, but if we have to go for specific disclosure, we anticipate that will cost 30,000, so that you're not just putting in a lump sum as a margin, but you are identifying discrete elements that might possibly arise, and if they did, what you say the likely
almost
cost
like a
would
shopping
be.
list.
A shopping list, yes.
Of potentials.
Yes.
I mean, you can't argue it. It's got to be the right thing.
You know, we may or may not need potatoes.
The trouble with contingency, or the message we're getting from contingencies is that you should put in the contingencies, because if you don't and they were predictable, you won't be allowed the costs at the end. You won't be allowed to add them, or you won't be allowed to vary.
See, I don't think we've had a decision yet dealing with this. See, if I was back in practice, I would throw in loads of contingencies, broken down appropriately. You know, if this happens, then this might be the case.
I would also have a boilerplate, couldn't you? You'd have a list, shopping list again.
So I don't want to give out some make judges' life any harder, but I do think that. But I would think about that. Okay, final case to very, very briefly mention, Board of Trustees Merseyside against AEW. Now this was dealt with lots of issues. I would recommend all practitioners read this case. Deals with interest under the Late Payment of Commercial Debts Act, indemnity costs, and interim payments on account of costs, as well as cost budgeting for good measure.
It's all there.
So this case, an interim payment was being made. Unfortunately, the old budget had been superseded, but the revised budget hadn't been properly brought to the attention of the courts. Okay, what do we think the interim payment was made by reference to, the old or the revised budget?
Old budget.
The logic is the old budget, isn't it?
In this case, it was by reference to the revised budget.
Okay.
So this goes against Elvenite a little.
Well, let's hope for us all then.
Exactly. So the differences that were pulled out here by Mr. Justice Aikenhead in the TCC were that it had been a very busy day at the date of the PTR when the approved budget.
He was having his senior partners having their hair done, the nails. The poor man. Anyway,
I didn't want to laugh at that particular point, but that's a shame.
Oh, God.
Okay, there was no suggestion that the revised budget was objectionable. It was an oversight by both parties. Neither side took issue with the other's budget. I think this is a key point. There had been substantial amendments to the statements of claim, statements of case, and the complexity had increased. So, and also crucially, Mr. Justice Aikenhead said he would have approved the revised budget. So,
I mean, I'm hopeful that as things settle down, that it'll become much easier, not only from us but from the judge. Some sense will come to this. It's about budgeting, timing of it.
Sure. We'll move from the current, what seem to be quite extreme positions, and we'll come more towards the centre ground.
I think so. And it'll be interesting. I think everyone knows that Mitchell's coming up for in the Court of Appeal on the 7th of November. I think they'll give quite a quick judgment. It's Dyson.
It is Dyson. They won't want to hang about, and everybody's waiting. This is so important.
And everyone's waiting, and mixed views about it. I mean, they could find on the facts, I think, of this particular case, because they are slightly extreme. I mean, they are very quite subjective.
That's the concept. I'd like them to go wider. Obviously, I think we all would, wouldn't we?
Yeah. I mean, well, to some extent, we'd like them to produce a sensible solution to it all.
And David, and of course, it's as much a decision about relief from sanctions and 3.9 as it is about budgeting,
Yeah, well,
which in the long run is going to be much more important, I
Well,
think.
interesting in a way is that when we look at Jackson in the last 6 months, it's all been about relief from sanctions.
It is, yeah, because
Mitchell is a relief from
Yeah,
sanctions.
they are. That's absolutely
it's
the point.
3.9.
Yeah. And so, although budgeting is the scenario, the truth of it is how hard is hard.
Well, when we look at 3.9, because 3.9 changed in April.
Yes.
And
the
reduced.
Infamous shopping list, as Dyson called it.
The shopping list went.
Yeah.
And
no more Tara Masalata.
No. And everyone tried to look at what is a standard for 3.9.
Yeah. So we have just two specific factors now, which are whatever it is, compliance and
everyone is looking at the Tara Masalata because they're looking at that list.
They are
that they had previously.
But where are the green olives? That's what I want to know.
Anyway, one final quick point on Mitchell. I think that this demonstrates that 3.9. You're absolutely right. It's really a 3.9 appeal.
It is. Yeah.
But Master McLeod very revealingly said that because she was hearing this relief from sanctions hearing, she'd missed out on hearing an asbestos claim, a really important asbestos claim, where the claimants don't have very long to live.
Yes.
So I think that's a really useful illustration of the point of 3.9 about balancing judicial resources.
Well, and overriding objectives.
Exactly.
Yeah. Justly proportionate cost. Big stuff.
Well, thank you very much, Neil. Let's turn to Dominic. Dominic's going to try and give us some idea of actually this isn't the end.
No. Well, it is.
Off we go.
No. It isn't the end. Right, next year, things on the agenda, starting with budgeting, I think it is likely that it's going to be declared that budgeting will only apply to Part 7 proceedings rather than Part 8 proceedings, because there's been confusion about that. On small claims, there was much talk about the injury small claims limit rocketing upwards. I think that is now diminishing, and indeed the fact that the Minister has just said that they're going to look at sort of panels of approved doctors for writing reports, that seems to suggest that they're going to be dealing with perceived problems, but not dealing with them by just an almighty hike in the small claims limit. So my view, for what it's worth, is I do not see a colossal rise in the injury small claims limit. Work has started on updating Part 36. This will probably not come in until October 2014. They are going to, it is intended to drop the requirement that an offer must say this offer is intended to have Part 36 consequences. They are looking at the rewards regime, which again you'll see mentioned in the survey. And at the moment, if you make a good Part 36 offer from the 1st of April, claimant can get up to an extra 75,000 in damages, all well and good. But in multi-million pound cases that David handles, £75,000 is neither here nor there. So the reward regime be extended. So removing the cap, and because it's capped at the moment at £1 million, ought it not to go somewhat higher? And they are also trying to work out a way of making Part 36 more amenable for defendants. The problem of if a defendant makes Part 36 offer and the claimant accepts it, the claimant is then entitled to the costs of the proceedings. That is something that they are, I think, they've had 3 meetings now, so a lot of work is going into Part 36. The one that really intrigues me, and I'm grateful to David for telling me that the case has just been published, called PGF in the Court of Appeal, but it is now quite apparent that the Court of Appeal feel that they got it wrong in Halsey in 2004, when the court said that one cannot order parties to mediate because to do so would be to breach Article 6. The Court of Appeal are now moving away from that position, and I think there's going to be a concerted attempt to push ADR much more firmly. Indeed, in his introductory essay to the White Book this year, Sir Rupert says that in general, every case really ought to have gone through some form of ADR process before it ever gets to trial. So query, are they going to rewrite the rules? Certainly the Court of Appeal is being more creative, but I do think there is a prospect that the Court of Appeal is going to take go off in a new direction and push mediation.
That's got to be the right
before.
way, hasn't it? It's got to be the right way to go.
Well, PGF is in PGF. There was talk of mediation coming from the claimants, and there was no response from the defendants.
Right.
And that was the point that the Court of Appeal highlighted, is that there was no response.
There's got to be you've got to
It
cooperate.
went towards trial. There was a
Yes.
Part 36. It went towards trial. The Part 36 was accepted at a very late stage. And the costs would have followed in the usual way for the defendant, but the defendant was restricted on its costs because it had not responded to the overtures on ADR.
Yeah.
And,
another
and quite a
step.
hard. It's a step up from Wolsey. I mean,
It is.
very
And
much so.
may I say, therefore, it's a stunning tactic for claimants to be writing every time from now on saying, we are prepared to mediate, and put the defendant on the spot.
I would hope that you wouldn't have to respond to every single, as long as you've given the general suggestion that you're not, you've considered it.
Yes.
I would hope that you wouldn't have to respond to every one of the 15 requests for ADR, because that'd be a worry.
Yeah. Well, I suppose one request would do the trick, but I think certainly the judiciary feel that cases should not be going to trial, and therefore that ADR can be a magnificent method of preventing matters going to trial. And of course that then meets the Jackson criteria of settling cases faster and presumably more cheaply. So I can see a very powerful argument to push in that direction.
There's always a danger of overemphasis, I think, on mediation.
Oh yeah.
From, as a litigator's point of view, is I'm quite capable of negotiating with the other side, and I think mediation has its place.
Well, it's all about talking to the other side.
I think the important point of it looks like coming out of PGF is that you must respond to any overtures in relation to mediation or ADR in some fashion.
Yes.
Even if it is, it's not worth it. I don't
It's
like
not-
your offer.
No.
Or indeed, from a claimant's point of view, we might say, well, why don't you make me an offer?
Yeah.
And I'll talk about it.
Have you ever had any cases in practice where you've thought they've been implacably unsettleable, where mediation has actually done the trick? Because I remember a couple of cases of mine where I've been pleasantly surprised by how well mediation has worked.
I think if you're an experienced litigator, I mean, you see mediation as a method of trying to resolve.
Yes.
And I think but I do see it as a method of negotiation.
Yes.
I have someone sitting between the parties, but I do very much see it as a process of negotiation. It's a fascinating thing, of mediation.
Yeah.
Psychologically, is the way it works, and sometimes they work, sometimes they don't.
Yep.
Okay.
Let's. Anything else?
Well,
Tommy,
the only other thing I want to mention.
Any more secrets?
Well, it's not a secret.
Jackson box.
It's not a secret. And in fact, he concedes this in his essay again in that introduction to the White Book. Nobody knows what on earth proportionality means, and that is going to be the next battleground.
Yes.
That is where the real litigation is going to be.
Yes.
How the hell, we look at Neil's numbers here, when are these numbers proportionate or not? We don't know.
Is it a percentage? Is it
Well,
as crude as that?
I think the interesting question for the future is, what's the relationship between proportionality and the budget?
Yep.
Yeah.
How is that going to work?
Sure.
Because you're looking at a budget in relation to a claim,
Yeah.
but of course you will be looking at it subsequently in relation
Yes.
to either a settlement
Or the recovery.
or the judgment,
Yep.
Sure.
which may be a lot lower, and it may
Yeah,
look disproportionate.
yeah, yes.
I haven't quite worked out how that's
no.
going to
Are you
work.
leaving
No,
open the
no.
possibility of inflating the size of your claim to make it look proportional?
Well, I don't know about inflating it.
But-
Inflating side. We don't inflate claims. We make real claims.
We may settle for realistic or lower levels, yeah. Well, of course, may I just say perhaps a final thought here. In Troy Foods and Manton back in April, Morbic said that the mere fact that a budgeted figure was approved did not mean it was proportionate, and that brings uncertainty. So you're right, absolutely right, David. Where are we? So there's plenty of litigation out there.
Can I cover, before we finish, just a couple of points? I wanted to cover a funding issue, and that's about ATE policies and where the ATE market is going. I think from a litigator's point of view, the non-recoverability of ATE premium causes us huge difficulties, and how is the ATE market responding to it? And I attended something the other day, and someone from a big insurer was there, and I said, yes, but tell me, what product are you going to sell? What are you now selling, and how are you selling it to solicitors needing an ATE policy? Do you want a premium up front? Are you going to defer the premium?
Yeah.
Are you going to have a mixture? And actually, I think it's likely to be a mixture, and that's the sort of noise we're getting from the ATE market. There are still quite a lot of providers providing premiums that are deferred, because that depends on having cash at the end of the day. So they're much more sensitive to the availability of cash.
Yeah.
So I think we wait and see on the ATE market how that's going to pan out. I have to say is I think they're a little uncertain as to how they're going to organise it, and we haven't quite seen the relationship between ATE and DBAs and indeed third-party funding that I think will develop over the next couple of years and may well change the market in terms of funding. The other point I wanted to cover that we're looking at the moment is guideline hourly rates. They are being looked at by a committee of the Civil Justice Council, and there is a questionnaire coming out to practitioners in the next few days. I think it goes live on the 1st of November.
There's an exclusive.
We'll see a questionnaire. I would urge people to complete the questionnaire. It's very important. We're trying to get some detail into guideline hourly rates. They haven't moved since April 2010, so there's some catching up to do on guideline hourly rates, and they're very important. I mean, as we've been talking about, is how do guideline hourly rates sit within the budget? What are you putting in with your budget for guideline hourly rates? Or are you putting your private rates in the usual way? I think we're likely to see a hike in guideline hourly rates, but we'll wait and see. So there is a questionnaire.
Hike or modest upward adjustment?
Well, they haven't increased since 2010. I think there may be some question about their realism at the time back then.
Yes.
I think too low.
I think what we'll see is what we're attempting to achieve is to ensure that there's some evidence behind guideline hourly rates.
So there's a rational basis
for adjusting. You know, it's not sticking a finger in the air and deciding that there'll be a rational. And we'll see. We've got the areas for guideline hourly rates: City of London, certainly in London, West London, those types of districts, and outside London, in the cities, Birmingham, and elsewhere for those rates. We're likely to keep that. I don't think that's going to change. There has been discussion about changing them in relation to work, the type of work that might be undertaken, but I think we're not going to have the data for that. I think that's a difficulty. So it's quite a short questionnaire. Please complete it, and it has to be back by the end of the month, and we'll see. I think the guideline hourly rates likely to change sometime next April, May, something like that. So it's an important point. Anything else, gentlemen, you want to add to the survey and the changes and where it's going? Any last words, Dominic?
No, I think we are where we are, and there's a lot ahead of us, and it's now for the judiciary to shape it.
Super. Neil?
For me, bring on Mitchell. That's what I'm waiting for.
Bring on Mitchell. Well, that's a few days away. Just to finish, this survey has been undertaken with the London Solicitors Litigation Association and the New Law Journal. It is intended to try and repeat it on a quarterly basis to see how Jackson develops and whether people's opinions change over the coming months and years. Thank you very much for listening to us and watching us in these discussions. I hope that it's been helpful, and we hope to repeat the exercise soon. Thank you.
Great. Thank you.
Thank you.